eventually manage to apply any charges to him? Did you send him
Wait,
off?
I'm trying to. Are you
Yes.
guys the one? Hold up, I've had 2 encounters today.
No, we're referring to this one.
I know, but like, I believe I did. Are you the lawyer that got kidnapped and killed?
No.
Yeah, that is me.
Okay, so yeah, we did apply charges at the end.
Okay. What was he charged with?
Speeding, refusal to, evading arrest.
Mhm.
Let me think. Oh yeah, refusal to follow a lawful order, so to stop the vehicle.
Mhm.
And let me check what else it was.
So we have speeding, evading arrest, disobeying a lawful order.
And it was 1 second. I believe it was disturbing the peace and disorderly conduct.
Disorderly conduct. What was the prison term?
What was the what?
What was the prison term? How much time did he serve?
I believe it was 415 months.
Okay. All right. So at no point in time he pulled a firearm, only after, at the end, after being tackled and hit with a baton, right?
Mhm.
Okay. So how long was your chase for?
Roughly from about 30 seconds to 50, maybe a minute.
That's it.
Yes, sir. That was
Okay.
from Polito Bay, then him speeding and recklessly driving across the entire highway, and
Okay.
then him crashing.
All right. Very well. So he didn't pose a risk or a threat to you directly.
Well, he posed a threat to everyone on the road.
Did he collide with anyone?
He collided with a BCSO unit, yes.
Okay.
Objection. I was rammed multiple times.
Who's objecting?
Jack,
Me,
he's
Jack.
objecting because he's saying that he was rammed into the PCSO unit.
So only attorneys can object. Okay. So
Okay.
that's all right.
That's why I said it for him.
Now, when you were allegedly rammed, since there is no proof of this, no footage that can evidence that claim, I'm going to overrule that objection as hearsay. We don't have the footage, so there's no evidence of it. Very well. So, what, what if you can provide the court with a statement, officer Evan?
What?
If you can provide the court with a statement to this question, if he's not posing a threat to you, he has no firearm, he's on his 2 feet, and has no weapon displayed as of that time, how would you justify utilizing the baton? I would like to hear your argument.
Well, let's say he was, hold up, in this circumstance, did he run away or was he just standing on the street?
It appears to be that he's running in circles.
I would use a baton. And I would justify that by a less than lethal option.
No, I understand. What I'm trying to understand is your rationale.
My what?
Can I say something really quick?
Go ahead.
So you're saying that you're using a less lethal option, But when you started attacking him, he was already tackled by the other BCSO unit. So when you were attacking him, it was basically
Well, sir,
useless. You could have cuffed him.
Well, sir, in my eyes, I couldn't. I simply. How do you say this? In this context. My eyes didn't register that he was tackled until I was already doing the action. You know what I mean?
I see. So your perspective was that he was still standing.
Well, he was falling. But like, like with my eyes and with my body, when you kind of like use a muscle, then like the action takes a couple seconds.
Okay, but why did you repeatedly hit him then?
I didn't repeatedly hit him.
Clip, you hit him
Wait,
like
did
5
I?
times.
How many times can be witnessed the attempt to hit? Was it an actual blow,
Well,
or was it an attempted blow? Did you
well, as we
miss,
know,
or
what?
did you miss, or did you actually hit him?
Well, I think towards the end I had hit him.
Okay. And how many attempts did you make to hit him?
3.
Okay.
But of course, when everything's happening so fast, especially in a situation like that, it's hard to control actually how many times you can, especially with your muscles.
Okay.
Especially when they're running away from you and you don't know if your strike will hit them.
What is the plaintiff seeking to resolve the matter? Attorney,
Oh, sorry. What did you say?
what are you seeking for resolution?
It's up to him, honestly. I mean, we were thinking. I don't know how much. Jack, what are you seeking?
I'm not sure how much can I be awarded.
That's gonna
How
depend.
much did the hospital cost?
That's not
And
standard. Just because the hospital costs,
what?
you can sue somebody for anything. It's not just like reimbursement for hospital costs. If you
So
assault on
like,
him, he can sue you for any amount. It's up to what he wants to sue for.
Is there any evidence of physical examination, physician reports, diagnostics, imaging, any of that?
No, because as soon as that ended, he was instantly brought to the police station. He wasn't even treated for his injuries.
because he didn't say that he was injured.
Well, either way, that's what I'm saying. He was just instantly brought to the station.
So what are we seeking for resolution?
Jack?
I am seeking 100,000. No, 200,000. 100,000 for the unlawful physical conduct, and 100,000 for the emotional and physical pain that it caused me.
I'd say that's fair.
So, Officer Evan, is there any closing statements that you would like to provide, or anything further you would like the court
No.
to know? Okay. Is there anything on the side of the plaintiff that you would like to voice before sentencing, or are we good to proceed?
I think we're good to proceed.
Okay. So after receiving the footage, which is the sole evidence submitted, it is noted that Officer Evan has no footage of his own, and after hearing both of arguments, the restituted amount requested and the evidence provided to the court so that would aid in justifying the request for restitution amount. You have to bear in mind that when someone is breaking the law, you have to be very, very specific with how many miles per hour above the posted speed limit the individual is driving. We have absolutely no evidence that he did any speeding. We have absolutely no evidence that he obstructed justice or any of the charges, evading arrest, disorderly conduct, for which he has already served a prison term. So if there is no evidence to sustain these charges, this is just a mere mental note. What happens if the case reaches the bench of the Department of Justice? We are required to uphold the rule of law. No one's above the law. And statements along the lines in trying to persuade justice to tip its scale towards your benefit won't work. It has to be just and fair. And while though I may very well believe that he was engaged in criminal activity, there was no evidence to sustain the need to use a baton. Your taser should have been your very first method of rendering the suspect.
Can I butt in?
Excuse me?
Can I object or whatever it's called?
Attorney.
You can't object to me.
That's my bad.
It's okay. You can object only to opposing party. So the conclusion that this court reaches, based upon the lack of true evidence other than just a mere 10 seconds, the court won't, however, allow anyone to mislead it. If you manage to capture 10 seconds, we're sure you must have more footage, but that's all right. Based on the evidence submitted, the court does find that the amount of force utilized against the plaintiff was exceedingly, as standard operating procedures state, matching force is required. But if no force is being applied onto you, how would you justify utilizing a baton? Matching force are the words here. He didn't employ any force towards you, yet you applied some force onto him. So the technicalities here would have justified you if you would have utilized your taser instead. It renders him in a subdued state, but instead he was tackled and hit over the head. And although this court has not received any evidence to support $200,000 worth of claims, it is, however, going to grant $150,000 in the form of restitution payable immediately to the attorney of record or the plaintiff directly. Now, this court is adjourned. Thank you for your time.
Thank you, Judge. Or Your Honor, sorry.